Today on Rochelle's Daily Wire Video Edition, we have another Supreme Court update. The so-called long conference of the Supreme Court will be held on September 27th. They call it the long conference because it is the first time the judges get together after their summer recess to consider granting or denying petitions for certiorari. And it's a long conference because there are literally hundreds of cert petitions that have stacked up for their consideration. There were 3 bankruptcy cases scheduled for consideration at the long conference on September 27, but one of the cases evidently has settled, and so now there are 2. In addition, there is another bankruptcy case on the court's calendar for consideration at the conference on October 8. Well, I've previously written about what these cases are, so I'm not going to get into it now, but I just wanted to let you know that should there be a grant, or for that matter, a denial with regard to those 3 petitions, we'll let you know right away on Rochelle's Daily Wire. By the way, it's possible that I won't be saying anything because very often the court cannot make up its mind at the long conference about some of these good cases, and believe me, these are 3 pretty good cases that certainly merit the court's careful attention. Whether they grant them or not, I don't know. Time will tell. I also want to report that there is another case that is right now going toward the 10th Circuit Court of Appeals that stands a good chance for having a grant of certiorari, say, somewhere a bit in excess of 1 year from now. There is already a stark split of circuits on the question of whether or not the issue of sovereign immunity applies when a bankruptcy trustee is using the power under Section 544 to bring a claim against the federal government, usually the Internal Revenue Service, for receipt of a fraudulent transfer. Now, if a trustee is merely suing under Section 548, or for that matter, 547 of the Bankruptcy Code, there is a clear waiver of sovereign immunity in Section 106. However, it's a different subject when a trustee is exercising powers under state law, because the government says an individual cannot sue the government for a fraudulent transfer on behalf of someone else, and so therefore a trustee who steps into the shoes of an individual actual creditor is barred by sovereign immunity. Well, as I said, the courts are already split, with the 7th Circuit one way and the 9th Circuit the other. And as I said, the 10th Circuit is going to have to weigh in on this issue. I am pretty sure that the government wants to take this all the way up because this case in the 10th Circuit only involves $150,000. And I can't imagine that the government is going to put the kind of resources that are required into 3 or 4 levels of appeal when that little money is involved. So that's why I think once we have a decision from the 10th Circuit, one side or the other is going to file a petition for certiorari. And when that happens, I'm pretty sure the government is going to urge the Supreme Court to grant the petition and resolve the circuit split. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. I will return same time next week with something interesting from the world of bankruptcy. Until then, be well, stay safe, good day.